Merci aux organisateurs de nous avoir associés à ces colloques. So we'll discuss the extent to which the global approach of external action objectives in the new generation of free trade agreements may affect the autonomy argument, the autonomy claim. In the late case law of the Court of Justice, the autonomy claim is linked to the identity of the European Union in the international legal order and with regard to the member states. The autonomy claim raises the question of its content, what exactly means autonomy, which covers the responsibility to ensure it, and so the exclusive jurisdiction of the Court of Justice. We know that in the new generation of free trade agreements, the mechanism provided may be liable to affect the exclusive jurisdiction of the Court of Justice, and thus the notion, the concept of autonomy, the autonomy of the legal order of the Union. But this is not the scope we adopt for our paper. We rather focus on the content of the autonomy, defined in the case law of the Court of Justice, and namely in Opinion 213 concerning the accession of the Union to the European Convention of Human Rights as a self-referential legal order. Exactly, the court said that the autonomy enjoyed by EU law in relation to the laws of the member states and to international law requires interpretation of fundamental rights in that context, but of any other provision, in the framework of the objectives of the EU. So our starting point is that autonomy means preserve the identity, the integrity of the EU legal order as a self-referential legal order with regard to international law and to member states' action. So the question is the balancing exercise between openness to international law and preservation of the integrity of the specific characteristics of the EU legal order. In the context of the new generation of free trade agreements, the autonomy is questioned because there is a necessary balancing exercise inherent in the construction of this kind of agreements. We have a global approach, a comprehensive approach of external action objectives linked to the general objective of making of the Union a global international actor. At the same time, the principle of conferral, which is an essential characteristic of the EU legal order, has to be preserved. So we propose to see this balancing exercise in two times. First, in the delimitation of the external competences, which is also an element of the autonomy claim, in the sense that the division of competence is defined by the Court of Justice itself. In the first place, we will see the autonomy claim in the delimitation of the external competence with the material we have at our disposal, which is the Opinion 215. So I will come back to some considerations which can be discussed, but from the perspective of this autonomy claim. And in the second in the second part, my colleague Mauro Gatti will deal with the autonomy claim in the context of normative conflicts, the balancing exercise between the global approach of objectives in the new generation free trade agreements and the internal policy objectives and the preservation of characteristics of the EU legal order as stem from the text of the agreements, from the action of the institutions. So I will deal with the autonomy claim in the delimitation of external competencies. The main structural characteristic of the EU legal order is the principle of conferral, the relationship between objectives and competencies. Its competence correspond to a specific objective. But in these new agreements, we have a comprehensive, global approach of objectives, and the question is how the court deals with that and the way, the extent to which it accepts the definition, it accepts the existence of a more broad competence without affecting the principle, violating the principle of conferral. So the question is how the Singapore opinion deals with this balancing exercise, a global objective, but taking into consideration the sectoral, fragmented approach in the principle, inherent in the principle of conferral. So I will recall 3 points of the Singapore opinion. First, concerning the scope of the common commercial policy with regard to the sustainable development provisions, which has been largely discussed. And as it has been explained, the Court of Justice adopted a broad definition of the common commercial policy objective, covering the sustainable development, the environmental standards, and the labor standards included in the Singapore Agreement. However, the Advocate General Sharpston considered them as autonomous objectives, giving rise to an autonomous to a member state competence. The question is the way with which the court deals with this question, what it shows with regard to the in relation to the autonomy argument. The court considered that the fragmented approach can be overcome because it didn't see the environmental objectives, the labor objectives, as a horizontal objectives taken into consideration, but considered them as inherent in the commercial policy broad objective. The court went beyond the fragmented approach of competence and objectives and considered that the objective to be a global actor reinforced the autonomy of the EU with regard to member states and to international law. So the Union appears as a global trade actor, and in the sense that the court accepted the autonomy with regard to international law. It didn't consider these objectives as values, didn't consider them as imposed by international law, but considered them as inherent in a broad conception of the common commercial policy. In the way, I take it again. The court didn't consider them as a center of gravity exercise. It didn't consider the commercial policy objectives and the autonomous objectives for environment and labor standards as subsidiary, as ancillary objectives. It didn't make this balancing exercise following a fragmented approach, which is appears in the present case law. But it included this objective in the broad definition of a common commercial policy. In a way that did not deviate from the principle of conferral. So this broad definition of common commercial policy means that the court considers that the objective which is not inherent in the common commercial policy are not seen as imposed by an international law, are not seen as transversal objectives where we have to make a balance and see where the competence is based, but the competence in the commercial policy is interpreted in a broad way, in a way to include other policies. So the court overcame, went further of a fragmented approach, and there we can see a reinforcement of the autonomy with regard to the international law, because these provisions are imposed by international treaties, and with regard to the fragmented approach of competences, considering that there is no way to see what is the main competence. It is one competence, commercial policy, which is interpreted in a way to cover other objectives. So I think that we can discuss this approach of the court from this perspective of autonomy. The second point where the autonomy argument, the autonomy claim may be discussed is the position of the court with regard to the termination of bilateral investment treaties of the member states. According to the Advocate General, whatever the competence is, it is for the member states to terminate the treaties, because the member states are actors in international law with regard to third states. The court took another view and considered that it is not a question of competence, but it is not for the member state to terminate the agreements. So the court went beyond the unity of representation, because unity presupposes that we have member states as actors. The court considers that member states are no more actors in international law. So once again went beyond not only the competence question, but also the unit of representation with regard to the objective to reinforce the position consideration of the Union as a global actor, as a unique actor in this regard. But at the same time, the specific characteristics of the internal legal order should be preserved, because it's also a question of autonomy. And the court is not allowed, does not allow itself to deviate much from the principle of conferral. So that can be also linked to the previous consideration of the link between commercial policy and sustainable development, because it considered the competence. It considered that the competence of in the commercial policy field is to be defined with regard to the broad objective. So once again, linked one competence to one objective, even if this objective is can cover the other ones. And this consideration to respect the very essence of the union construction of the union is also to be seen. A third point, the investor-state dispute settlement provisions, where unlike transparency or judicial protection, the court did not consider them as institutional provisions which follow the division of competencies, but consider that as far as the investor-state dispute settlement provisions may affect the competence of the national courts, and then the internal order, the internal legal order of the union, the characteristic of this order is the composite character, the implementation of EU law by member states. Then it's linked to a question of competence in the external field. So as far, even if we are in a field of exclusive competence of the Union from a substantive point of view, from the procedure from the implementation point of view, as far as the jurisdiction of the member states' authorities is to be affected, the court linked it to the question of competence in order to also in a very autonomous approach consider that the objective to make of the Union a global international actor is to be reconciled with the main characteristic of its legal order. And this balancing exercise is also obvious with regard to the normative conflicts stemming from the specific substantive provision of the agreements, and Mauro Gatti will talk about that.
If I do I reach the microphone like this? OK. Merci beaucoup pour l'invitation. Je vais être bref par rapport aux questions des conflits normatifs. And I'm actually going to do that in English. When one wants to assess the content of autonomy in EU law, it is necessary to look at competencies first, but it is also necessary to look at substantive rules secondly. And the issue in substantive terms in this case relates mostly to the problems between new FTAs and substantive laws enacted by the Union and the Member States in the pursuance of public interest objectives. I can anticipate the conclusion, just briefly, just to give you a first idea of what I am going to talk about. The idea is that what the Commission has done in the negotiation of new FTAs reminds, in a way, of the jurisprudence of the Court in Opinion 215, in the sense that what the Commission tried to do was to insulate the EU's legal order to protect its specificities, including the relationship between the Member States and the Union. Now, in what way the new FTAs are problematic for the Union's autonomy in terms of normative conflict? The answer is quite simple. New FTAs, as Eleftheria noted, are very broad. They contain numerous elements, and potentially they may interfere with any kind of legal act adopted by the Union of its member states in more or less any area. Investment provisions are particularly problematic in this respect. And one is extremely, problematic, and it is the clause on fair and equitable treatment, which is actually notorious in arbitration cycles, or famous, it depends on your point of view. If you are a multinational, that's very good. Fair and equitable treatment, as you probably know, is a very vague clause that is included in almost all or all investment treaties, including the new FTAs negotiated by the Union. And that stipulates, very simply, each party shall accord to the investors of the other party fair and equitable treatment, without specifying what fair and equitable treatment means. What arbitral tribunals do in practice is to interpret this clause in a very extensive fashion in many occasions, which leads them to protect the legitimate expectations of investors even when states actually pursue public interest objectives and have absolutely no discriminatory intention. Let us make a practical example: Philip Morris versus Australia. Philip Morris sued Australia because Australia had enacted a law imposing plain packaging obligations. The problems caused by fair and equitable treatment clauses are generally recognized also by policymakers, especially after certain protests by public opinion organizations, because this kind of clauses encourage the so-called regulatory chill. States tend to not regulate certain areas because they fear being sued by multinational companies. As you can imagine, this means that states lose autonomy. That is, the capacity to define their own laws. That is literally the meaning of autonomy, autonomous, self-law. So this is really a substantive dimension of autonomy. And the European Commission acknowledged this problem and introduced a very interesting solution to address it. It introduced a solution that has two dimensions. First of all, a dimension that is, let's say, a broad dimension, broad provisions that define a principle, the right to regulate. Article 13 bis of the agreement with Vietnam, for instance, stipulates that the parties reaffirm their right to regulate to achieve legitimate policy objectives, such as the protection of public health. Of course, this kind of clauses is very broad, does not create rights and obligations per se, but is interesting because it creates the policy framework and the legal framework for the interpretation of more precise clauses, which are also included in new FTAs. These kind of clauses, well, among these clauses, the most notable is precisely the one on fair and equitable treatment that is included in all FTAs recently negotiated. And this clause differs from the traditional free and equitable treatment clause because it is much more specific. This is a major innovation introduced by the European Commission, something that has never been seen before. The new fair and equitable treatment provision introduced by the Commission defines exactly what fair and equitable treatment means and what a breach of fair and equitable treatment means. And the list is denial of justice, fundamental breach of due process, manifest arbitrariness, and targeted discrimination. That's basically it. There are limited exceptions. What does this mean in practice? It means that arbitral tribunals cannot interpret the fair and equitable treatment provision or clause in an extensive fashion. They are bound to a strict application of this provision, which means that the European Union and the member states can adopt rules without fearing retaliation from multinational companies. This provision is likely to eliminate the problem of the regulatory chill. In other words, the European Commission, by introducing this kind of provisions, has eliminated the problems for substantive autonomy at the Union level, but also at the level of the member states, because these are mixed agreements. So I would argue that the fair and equitable treatment provision is likely to shield the Union legal order from potentially nefarious external effects deriving from international agreements. Therefore, these clauses preserve the autonomy of the European Union in a substantive perspective. These clauses also preserve the specificities of the Union in that they preserve the relationship between the Union and the Member States. Let us not forget that it is primarily the Member States that legislate in the public interest. It is primarily the Member States that introduce measures to protect public health or to protect morals. And the clauses negotiated by the Commission therefore protect mainly the legislative autonomy of the member states. So, making a general conclusion, I think that both the case law of the Court of Justice and the practice of the Commission demonstrate, first of all, that EU institutions perceive a great and display a great concern for the autonomy of the European Union, that this autonomy is characterized as a means, as a characteristic, as a necessity to protect the Union from potentially negative external influences, but it is also a means to protect the characteristics of the EU's composite legal order, in that it protects the delimitation of EU member states' competencies, as well as the free exercise of those competencies. In short, autonomy, as it is promoted by both the Court and the Commission, is a means to enable the Union to pursue its objectives. Its external objective of the activeness on the international scene, but also its internal objectives, public interest objectives like health and morals. I think that the approach of the institutions to autonomy is not simply a means to, well, to get power, a sort of power grabbing, a sort of make Union great again. It's really a means to enable the Union and its member states to discharge their functions. Thank you.
Thank you very much. Thank you very much for both of you. And as I'm an old man, I just wonder whether history is repeating itself once again, because while, for instance, Christine was speaking before and today, the whole debate is so similar to the one we had 10 or 15 years ago on internal competence. I know that the context is entirely different, but if you think about center of gravity, ancillary activities, balancing of interest, commission impact on the commission, the whole debate about the application of 114 on how to regulate the internal market, there's just so many similarities, in my view, with the debate we're having now. So I wonder whether some kind of lessons that we learn in that debate could also be exported in the current one. And we still stick to some kind of classics, because now we're going to move to discuss, another of the cornerstone of European integration, the loyalty principle in the conclusion, interpretation, and implementation on new generation FTAs, and Federico Casolari, professor from the University of Bologna. Again, another big and well-known famous name in the area of external relations. Please, the floor is